for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
The latest lawsuits of 2020, we've been talking about that hour number 1 or hour number 2. As I always say, deodorant applied and breath mints put in. So we're ready to roll. Here's the interesting one. What we do here at Radio Law Talk is a lot of people are talking about this, and it's throughout the news. It's in all these little articles, but they just briefly talk about it. But we dig deep, and Cal doesn't do this, but I'm telling you, we've got Todd digging deep, understanding this law and how it applies. But most people are just saying, guess what? You cannot now discriminate against dreadlocks, cornrows, or braids or hairstyles because that is part of a person's race. And this new law that comes in by a Democrat out of Los Angeles is now saying that these dress and grooming standards have an unfair impact on African Americans, and therefore they're discriminatory. And the first thing I thought is, what about those people who have dress standards? You know, and I get it, dreadlocks, and I get it. That's or braids or cornrows. But what if their dress standards are such that you can't have that? You can't have piercings in your lips or whatever you want in certain areas. Are they allowed to do that anymore in businesses? So Todd, you've delved deep into it. How does it apply?
Yeah. So what the law. Contrary to the way it's being pitched in the media, which is, oh my gosh, a new anti-discrimination law based on hair. And a lot of people even forgot to look that this was supposed to be an anti-discrimination based on race type law. So they started thinking, so somebody comes in with spiky hair and all this kind of stuff, I got to hire them without that. No, the law doesn't apply to any of that. What the California legislature did was, in the education code and in the government code, they added some language to the definition of race. And what they added was, you've got the definition of protected classes that can't be discriminated against, and in both sections they add this language. Race is inclusive of traits historically associated with race, including but not limited to hair texture and protective hairstyles. And they define protective hairstyles as including but not limited to braids, locks, and twists. And all this really does is further the way somebody can be potentially in violation of racial discrimination if their hiring decision is based upon that person's hair, and that person's hair is typically associated with their race. So, real-world application. Somebody comes in with an afro. Okay, that's typically associated with African-American individuals, and if they didn't hire them because of that, it's not hair discrimination, that's racial discrimination.
What if a white person walks in with a hair afro?
Well, if the white person walks in, that's not something typically associated with that race.
What if they were not pure white, but they're kind of more of a tan skin? How do you do that?
Well, so
I'm seriously. Where does this go? I'm talking about those of you out there. Listen, there's a slippery slope, we call it.
And here is why I should back up. Maybe if a white person walks in and they have an afro or they have cornrows or whatever,
or dreads,
look, that might be race discrimination for this reason. I know several individuals in my acting and stuff that, to look at them, I wouldn't be able to tell you what their race was based upon the color of their skin.
Right.
One guy individual in particular I know says, look, I'm African American. He doesn't look African American to me because his hair doesn't look that way, and his skin is
lighter, a little bit lighter.
I wouldn't be able to tell anything. It doesn't matter.
I had a friend that's Mexican that has blue eyes, and he has light skinned, but he came from Juarez, Mexico, which is kind of a more. It's interesting. You look at him, there's no way he looks Hispanic.
So my point is, you can't tell somebody's heritage or race based solely upon looking at their skin. So if somebody comes into your establishment and they appear to be Caucasian or appear to be Latino, but they're wearing cornrows or they have an afro, and you say, I'm not going to hire you, their argument would be, well, actually, I'm African American. You're not hiring me because of my hair, and the law says that's race.
Oh, come on.
Time to get back to Radio Law Talk on RadioLawTalk.com and on your favorite radio station.
Yeah, we're back. Sorry, we cut out a little quickly while Todd was talking.
My fault.
No,
fault.
that's okay.
Sorry, guys.
Cal,
Sorry.
we've cut your salary by 30 cents.
Dang it. It's my bad.
So anyway, getting back to the
back up a little bit. We're talking about the
hairstyle law in California. What it's been posed as, it's really just an addition to the definition of race in California and how it applies in both schools and in the employment context. And essentially what it does is it adds to the definition by saying race also includes characteristics typically associated with race, such as hair texture and protective hairstyles. And by hairstyles, they refer to, this is in the code, braids, locks, or twists.
Okay.
And I
said what?
Fred had asked the question, what if somebody who appears white comes in, or a Caucasian person comes in, but they've got an afro, or they've got
or appears Caucasian.
Yeah, appears Caucasian, and they have cornrows, or they have a hairstyle that's typically associated with African Americans. All right, and you decided not to hire them. Well, I think that you would expose yourself in a situation like that to race discrimination, because you can't look at somebody's color of their skin right now and conclusively determine their racial background. Over the break, I showed a picture to my colleagues of 3 friends of mine, and one of them was African American, and in looking at them, they all had very similar skin tones, and nobody could decide which one was African American, which was Latino, which one was Caucasian, and you just couldn't tell by looking at the picture.
Right.
And so if somebody comes in and they have that hairstyle and you don't hire them because you can't tell and shouldn't be able to tell based on the skin color, you expose yourself to racial discrimination.
So 855 Law Radio, you can call in and tell us what you think, or 855-529-7234, 855-529-7234. Here's the interesting question also. Is where does this slippery slope go? That's what I always bring up. A slippery slope is you're starting down the path where you're no matter what you do, you're discriminating. You know what I mean? Because you can't. Now it's how do you tell with the skin color? How do you tell with now it's the hair? Now, I mean, how do you know? I mean, I seriously put this on an application the other day. What race? I did not put Caucasian. I put other. And everyone's like, well, you're Caucasian. No. I'm like 22 different things. There's so many different things in my back. You go back and look at my genealogy. I'm Chippewa Indian. My family's comes from Chippewa Indian line. It's just there's all kinds of just mixture in me and a lot of people in America now.
When I was we all took in law school the class Trusts and Estates, I believe. That was one of the mandatory classes that everybody had to take because talk about wills and things like that. And one of the things I found interesting is that in the Trusts and Estates class, they said, genetically speaking, everybody on the earth is no further distant than 12th cousins.
Wow. Because
of the way genetics works and all of that. And so, yeah, to a certain extent, everybody has some sort of background. There is no... It's very rare to find anybody that would be ethnically homogenous to one area without any sort of DNA or somebody coming in from a different area. We're all people.
Now that DNA stuff's so big, it shows where you're coming from all types of areas.
I've taken upon myself the habit of writing prefer not to state because I don't want to reveal private information about myself to people anyway. So if they ask for race, how much I make, my education, I just put prefer not to state, and then I don't.
Yeah.
Now, a couple of things, and I was talking with Denise about this during the break. We have tried at Radio Law Talk to set up what the law is designed to apply to and how the law is designed to apply, and it's difficult to do that without sometimes sounding like you yourself are racist because of having to explain the way the law works and what the law is designed to protect against. And I want to be clear, just personally speaking, and I'm sure I speak for Fred and Denise as well, that I don't make it a habit to go around and try to, I wonder if that person is this ethnic background or that. People are just people. The 3 friends that I talked about, it was only for purposes of demonstrating an example and how you can't tell if you were
Sometimes
that type
you
of
can't,
person.
yeah.
if you were trying to discriminate or to delineate, but that's just not how I work. In the law, I should also say that there are also exceptions for bona fide security reasons and bona fide qualifications
in this new law. Explain that.
And what that means is that if there is a specific reason why there has to be a certain grooming standard, first one that comes to mind is the food preparation industry. If you have a hairstyle that it is impossible to guarantee and protect that hair is not going to fall into the food, then that's an issue. If it's a security issue, if you have to wear a helmet and your hair is such that a helmet cannot fit on, although looking at the NFL these days and some of the hairstyles,
the dreadlocks, yeah.
I would find it very difficult for an employer to be able to make that argument because these guys can wear helmets. But still, if it presents a security issue, if it's a qualified reason why the business has to have a certain appearance code, then there's an exception. Interestingly enough, there's also an exception for parents who employ their kids. A parent, if they want to employ their kid, can still say, you're getting a haircut.
Yeah.
if they want to.
Yeah, I'm curious, and I haven't seen this yet in the NFL. And I like watching the NFL to some degree. And I've seen guys with dreads or cornrows that are so long they're down the middle of the back. Let us know if you know the rules. Can someone tackle a guy and grab his
Yes.
dreads and flip him and just rip his head? Yeah, can he?
Yes.
Oh my gosh.
So here's something that's interesting. Okay, do you know what a horse collar tackle is?
Yes, I do.
So a horse collar tackle, for those of you who don't know, is you got the collar of the shirt, and then you have the pads that go around for the helmet or for the shoulder pads. And if you reach up and grab onto the back of the shoulder pad or the side of the shoulder pad, and you're using that to pull the runner down when you go to tackle them, that's a horse collar tackle. All right, illegal. You can't do it. Do you remember the Pittsburgh Steelers safety Troy Polamalu? Polynesian, had very long hair. I mean, it goes down halfway down his back. He had intercepted the ball and was running, and the wide receiver went to go tackle him and tackled him by grabbing onto his hair and pulling him down. Everybody thought it was a horse collar tackle. Nope. You grabbed the hair. You didn't grab the shoulder pads. There was nothing wrong with it. Although I don't know if they've changed the rule, but right now, the last time I saw it was free game, fair game.
It was part of the uniform, part of what you choose to put it out there. Yeah.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.